belongs to him, and further confirmed that the defendant was brought before him along with a black bag on 15th May 2022, that he took the sample of the drug exhibit and the forms for forensic analysis to Lagos personally on 1st August 2022, where the examination was conducted on same day and the results gotten the same day. PW2 Lance Corporal Shehu Zayano is a soldier by profession for 5 years serving with the Nigerian Army, that on 15th May 2022, during patrol on Operation Stop and Search, led by Warrant Officer Salisu Mohammed along Damaturu Maiduguri Road, a G-Wagon vehicle was stopped and all the passengers were asked to disembark, and while searching their vehicle, a black bag was seen, and after checking the bag, suspected codeine syrup bottles were found. That when the passengers were asked who owned the bag, the defendant affirmed ownership of the bag and then was arrested immediately and taken to their base at the military police detention facility, Presidential Lodge, wherein their commander gave them directives to take the defendant to NDLEA for further investigation on the suspected codeine syrup, which they did, and the defendant was handed over to the NDLEA through the second and third prosecution witnesses, Mainasara and Yahaya, respectively. Under cross-examination, PW2 confirmed that he was part of the team that arrested the defendant with 41 bottles of suspected codeine syrup, and that it was the defendant that informed him that he owns the bag. When asked how many of the officers were there when the defendant was arrested, PW2 said that he cannot recall the exact number. As a team of military police and civil police, therefore, he cannot say the number that went out for that operation. When further prompted if he knows one Lance Corporal Samuel Luka, the witness stated yes, it's a colleague, to which the defense counsel stated it was the same Samuel Luka that effected the arrest, to which the witness answered yes. He was further asked between the current statement that he effected the arrest of the defendant and now Samuel Luka, which one is correct? The witness explained that yes, when we say search, that is what we call man on the search, man on guard, and man on the watch. That he was on guard while someone was checking the vehicle and police was on watch. The defense counsel further cross-examined PW2 by stating that that means that it was the said Samuel Luka that arrested and took the defendant to you, to which the witness responded that no, I was there. While I was there giving him cover, he did not arrest and brought to me the defendant. Rather, we informed the senior person, Warrant Officer Salisu Mohammed, that see what we found here, and he came. During the examination, the prosecuting counsel asked PW2 to demonstrate how patrol was done and the division based on the question put to him. The witness stated, demonstrated by stating, as I'm standing behind closely watching, giving guard, PW2 demonstrated the position of the man on the search, man on the guard, and man on the watch, and that he was on guard. PW3, Yahaya Jibrin Adamu, this is an NDLA officer working with the Yobe State Command in operation and investigation has been there for 1.5 years, a chief narcotic agent by rank, that he knows the defendant whose name is Babagana Bako, and that he was among the NDLA officers who witnessed when some Nigerian Army officers under Sector 2 Provost by Lance Corporal Shehu Zayano brought in a male suspect, Babagana Bako, 24 years old, on 15th May 2022 at about 15:60 hours with exhibit suspected to be psychotropic substance. That the exhibit was field tested and it proved positive for codeine syrup, and when weighed, it was 4.1 liters of cough syrup. That all this was done in the presence of the suspect, arresting officer, and PW3 as the witnessing officer. That PW3 also stated that he remembered taking the statement of the defendant, and that the way the statement was given was that the defendant was given the cautionary word that he will not be forced to say anything unless what he wished to state, and that whatever he writes in his statement may be tendered in evidence, that he was asked to provide his lawyer and family member in whose presence the statement should be recorded, and the defendant told him that he will write his statement in the absence of lawyer and family member by himself. Under cross-examination, the PW3 answered that on the 15th May 2022, he was in the charge room in the office and that the defendant was handed over to him on 16th May 2022, and further confirmed that the said military officers that arrested the defendant later handed the defendant to him and informed him that the defendant owns the exhibit, that the defendant recorded the statement by himself on the 15th May 2022. The defense counsel asked the witness to reconcile the fact that the defendant was handed to them on the 16th May 2022, yet he recorded his statement on the 15th May 2022, to which the PW3 confirmed that he recorded on the 15th May 2022. PW4, Mainasara Emodishi. This is an NDLEA officer working with the Yobe State Command under Directorate Unit for 1 year now as a narcotic agent, that yes, he knows the defendant whose name is Babagana Bako, that on the 15th day of May 2022, about 16:50 hours, he witnessed when the officer of the Nigerian Army brought the defendant with exhibit suspected to be psychotropic substance. The exhibit was tested and it proved positive for codeine syrup in the presence of the suspect, arresting officers, and PW4. The exhibit was counted and found to be 41 bottles, weighing 4.1 liters, that all the processes were carried out in the presence of the suspect. PW4 also stated that he witnessed when the defendant was cautioned before recording his statement, and he said he will write his statement in the absence of his lawyer and relations. Under cross-examination, the PW3 confirmed that he was not part of the team that arrested the defendant, and that it was after the defendant was arrested and taken to them at the NDLA office that they were informed that the defendant owned the exhibit. And that the defendant was handed over to them on the 15th May 2022, that the defendant recorded his statement by himself. The exhibit tendered and admitted in evidence in support of the prosecution's case are also reviewed as follows. Exhibit NDLEA Babagana 1A, this is the certificate of test analysis form on which PW1 said he wrote the result of the preliminary test he conducted on the drug exhibit Babagana 5 brought to him by PW3 and PW4 along with the defendant. He stated in this form that he tested the sample of the suspected substance with the United Nations testing kit and found it to be positive for psychotropic substance. The form was printed by the defendant as the suspect, while PW3 and PW4 signed the form as witnesses of the preliminary testing. Exhibit NDLEA Babagana 1B. This is another NDLEA form named packing of substance form. The substance stated in this form is codeine cough syrup suspected to be a psychotropic substance. This exhibit was divided into two parts and labeled A1 and A3 respectively by PW1. The A1 was the bulk of the exhibit, and A3 was the sample put in an evidence pouch for expert analysis. This form was printed by the defendant and signed by PW1 as the maker. PW3 and 4 signed as witnesses for the divisions of the exhibit by PW1. Exhibit NDLEA Babagana 1C, this is the NDLEA form named Request for Scientific Aid form. This form accompanied the sample of the exhibit A3, forensic unit for analysis. It has the name of the defendant on it as a suspect. It carried the laboratory number given to the exhibit by the analyst, and it was endorsed by both PW3 and PW4, as well as the PW1 who filled it to accompany the sample he took to the forensic unit in Lagos. Exhibit NDLEA Babagana 2. This is the drug analysis report written by the forensic analyst that conducted the analysis in Lagos test, confirming that the exhibit A3 containing brownish liquid found to contain codeine, a narcotic drug, and has tested positive for psychotropic substance. Exhibit NDLEA Babagana 3. This is the transparent evidence pouch containing the remnants of the analyzed exhibit Babagana 2C attached with the request for scientific aid form. See the evidence of PW1, PW3, and PW4 above. 100 ml plastic bottle in a transparent evidence pouch with the case and exhibit number, the weight of the exhibit, the name of the defendant, and the names of PW1 and PW4 as witnessing officers. Exhibit NDLEA Babagana 4. This is the large brown envelope in which the forensic analyst enclosed the sample of the exhibit Babagana 2B, which he analyzed and addressed to the PW1 with reference number NDLEA YBSC 037-2022 and drug laboratory number NDLEA SD 2022-1693 written. Exhibit NDLEA Babagana 5. This is the bulk of the exhibit A3, which is the remaining 40 bottles, and they all weighed 4.1 liters in a black bag with the case and exhibit number, the weight of the exhibit, the name of the defendant, and the names of PW1 and PW3 as witnessing officers. Exhibit NDLEA Babagana 6. This is the handwritten extrajudicial statement of the defendant recorded by himself in English language and dated the 15th May 2022. It is a confessional statement recorded by the defendant and cautioned by PW3 before whom it was recorded. At the close of the prosecution's case, the defendant chose to give evidence in his defense. He gave evidence as DW1. The case of the defense is summarized below. DW1 Babagana Bako. The defendant is a 23 years old student at Yobe State University, residing at low-cost Damaturu, that on the 15th May 2022, he went to Maiduguri and on his way back had a discussion with a friend named Sadiq who called and told him to collect a package for him to take to Damaturu, and that on reaching the motor park, he was given the package to take to Sadiq. The defendant stated that he does not know the name of the person that brought the package, and on transit to Damaturu, soldiers stopped them. The defendant testified that after searching the vehicle by soldiers, they found the two black bags containing 41 bottles of codeine. And when asked, he told them that he was giving the parcel to take to Sadiq, who is a friend to a friend, that the baggage belongs to Sadiq, who is in Damaturu, and proceeded to give the soldiers Sadiq's phone number. The defendant was consequently arrested by the soldiers and taken to their base. From there, he was taken to NDLEA office, where his statement was taken. He testified that he gave the NDLEA the same statement he gave the soldiers, but they insisted that if Sadiq was not found, the defendant will be held liable, and that he made efforts to find the Sadiq by giving out Sadiq's phone number and where he could be found by both his family and the NDLEA, but they could not apprehend or find the said Sadiq. that he also gave the number of the person that gave him the baggage at Maiduguri Motor Park, but that the NDLEA informed him that they cannot go to Maiduguri to search for the person. The defendant stated that he did not check the baggage before collecting same because he never thought Sadiq would give him illegal goods. He says something by Kamataba or something that will harm him, and that was why he collected without checking. In that he trusted Sadiq, that the NDLEA did not go to Maiduguri saying that the unidentified person that brought the package is not in Damaturu, that the defendant should go and look for him, to which the defendant's family collected the number of the person in Maiduguri and went to find out that the number was not going through, and that the NDLEA refused to go to Maiduguri while the defendant's family said they could not locate the unidentified man or Sadiq. At the end of all, the NDLEA sent the defendant to prison where he stayed for more than a month before he was brought to court. Under cross-examination, the DW1 confirmed that the 41 bottles were found in his possession. When further asked that he took the goods from Maiduguri to Damaturu, as mentioned in his examination in chief, he clarified that the goods were brought to him, and when further asked why did the soldiers arrest him since he was not the only passenger, and he replied, they asked me to come out. DW1 was further asked if he has a license, permission, or any document that made it lawful for him to transport the exhibits from state to state, and he answered no. At the conclusion of hearing, both counsel waived their right to address, and the matter was adjourned to judgment. Above is the summary of the prosecution's case and defense put up by the defendant on the charge. In criminal trials, such as this one, it is the duty of the prosecution to establish the guilt of the defendant of the offense or offenses charged beyond reasonable doubt in order to secure a conviction. See Section 135, 1 and 2 of the Evidence Act 2011 on the burden and standard of proof in criminal cases and ways of proving the commission of a crime or guilt of an accused person. Excuse me. The Supreme Court held in Ari Bola Awoshika versus the state 2018 LPLR that, I quote, it is well-settled principle of law that an accused person arraigned before any court of law is presumed innocent unless and until he is proved guilty by his accusers beyond reasonable doubt through credible and reliable evidence, end of quote. See Olayinka Afola versus the state 2010, Okoro versus state 1988, Bakari versus state 1957, 3SC, etc., etc. It needs to be added that the burden of proof does not shift. Once there is the slightest doubt in the mind of the court, such doubt must be resolved in favor of the defendant, who should subsequently be acquitted by the trial court. See Alonge versus IGP 1959. Proof of the guilt of a defendant by the prosecution must be done through any of the underlisted methods, namely 1, voluntary confession of the accused person, 2, through direct, credible, and reliable eyewitnesses or victim of the offense account, depending on the circumstance of the offense, and 3, through circumstantial evidence pointing or focusing on the guilt of the accused person, that he was the one or one of the persons who committed the offense or offenses charged, and by no other person or persons but him. See Adio versus State 1986, Emeka versus State 2001, Egbohonomi versus the State 1993. In Mohammed Latif versus State 2018 LPLR, the Court of Appeal per Mohammed Ambi Usi Anjuma JCA on whether proof beyond reasonable doubt means proof beyond all iota of doubt and how is it attained, held that, I quote, it is right in law that the requirement that the prosecution must prove the commission of an offense beyond reasonable doubt does not mean beyond all iota of doubt. All that is required is proof that will reasonably fix the accused person with the commission of the offense. Such proof must be by a compelling and conclusive evidence. See Adewale Joseph versus State 2011, Rabi Ismail versus State 2011, Adebayo versus State 2008, State versus Akpabio 1993. The defendant in this case is charged under Section 19 of the NDLEA Act, which I've reproduced earlier. That section provides as follows: any person who, without lawful authority, knowingly possesses the drugs popularly known as cocaine, LSD, heroin, or any other similar drugs shall be guilty of an offense under this act and liable on conviction to be sentenced to imprisonment for a term not less than 15 years and not exceeding 25 years. In order to secure the conviction for the unlawful possession of narcotics under Section 19 of the NDLEA Act, the prosecution must establish the following three elements: beyond reasonable doubt that one, the substance was in the possession of the defendant; two, that the defendant was in possession of the substance without lawful authority; three, that the drug being confirmed is a prohibited or controlled drug. See Blessings versus Federal Republic of Nigeria, 2015 LPLR. In this instant case, the defendant is charged of being without lawful authority found and arrested in possession of 41 bottles of cough syrup with codeine, a suspected psychotropic substance. Being a criminal trial, the onus is on the prosecution to establish the guilt of the defendant by proving all the ingredients of the offense charged. The prosecution is not relieved of this burden even where the accused person had admitted the commission of the offense in his statements to the police or any other officer after his arrest. This was held by the Supreme Court in the case of Busari versus State 2015, in which it followed its earlier decision in the case of Ibadion versus the State 2000. See also Section 135 of the Evidence Act 2011. Therefore, the issue for the cause determination in this case is whether the prosecution has discharged this onus of proof placed on it by law in proof of the charge against the defendant. To determine whether the charge has been proved against the defendant beyond reasonable doubt in view of the evidence called by the prosecution calls for the review of the prosecution witness's testimony, which shows that the defendant was arrested in possession of the illicit substances to which he denied ownership. The exhibits were taken to Lagos to the NDLEA laboratory for forensic analysis, and which results confirm that bottles of cough syrup with codeine have proven positive for psychotropic substance. Thereupon, the prosecuting counsel tendered the remaining 40 bottles as the bulk of the exhibits recovered as evidence before this court, which the court admitted into evidence and marked as NDLEA Bagana 5. The primary duty of the court, whether in civil or criminal matters, is to accord both parties fair hearing and in criminal cases fair trial to the defendant, whereas the state is also accorded a fair opportunity to conduct its case in accordance with the best endeavors of counsel from the official bar, that is, the Ministries of Justice or the National Drug Law Enforcement Agency, NDLEA, as in this case. The defendant is a 23-year-old level 2 student of history department at Yobe State University. and is certainly denying being the owner of the exhibit, although he was in possession of the psychotropic substance, which the prosecution has charged him to court, that the exhibit belongs to one Sadiq, and that the defendant made efforts to assist in locating Sadiq by informing his family and providing the NDLEA with Sadiq's contact information and possible whereabouts. Unfortunately, the family's attempts to apprehend the said Sadiq was unsuccessful. The defendant also provided the NDLEA with the phone number of the unidentified person that gave him the luggage containing the exhibit at the motor park. However, the NDLEA refused to go to Maiduguri to search for the individual, claiming that the defendant should undertake this task by himself. In law, the burden of proof that the duty to prove the alleged offenses against a defendant beyond reasonable doubt is static. It is squarely on the prosecution, it never shifts. There is thus never any duty or burden or onus on the defendant to prove his innocence under any circumstances in our criminal jurisprudence when the prosecution has not proved its case beyond reasonable doubt, or at least on a prima facie basis against the defendant at the close of its case. See Adeyemi versus State, 2012, All Federation Weekly Law Report, where the Supreme Court had emphatically pronounced inter alia thus, in criminal cases, the burden of proof is on the prosecution, who must prove its case beyond reasonable doubt. Thus, the prosecution must discharge this general duty of rebutting the presumption of innocence constitutionally guaranteed to the defendant. This onus, as I stated earlier, never shifts. I have watched the defendant while he testified in court, and he appeared to me to be telling the truth, and I believe it's evidence. There's a common denominator in the testimonies of the prosecution witnesses and that of the defendant. And also, having perused the extrajudicial statement written by the defendant in the custody of the NDLEA, there was no discrepancy. All the facts were corroborated, but alarm bells kept ringing in my head to the fact that this defendant, being a student, was used as a mule to transport the exhibit from Maiduguri to Damaturu, but the NDLEA did not extend the scope of investigation to find out who the unidentified person that handed the defendant the exhibit and who Sadiq, the alleged owner of the exhibit, is. It is my humble view that in criminal matters of this nature, the prosecution ought to bring before the court all the material facts at their disposal, both those in favor of the case and those not favoring the case. The prosecution failed to investigate whether there were such persons as the unidentified person that gave the baggage containing the exhibit, as well as the Sadiq, whom the defendant claimed owns the exhibit, and asked him to assist and to assist it and take it from Damaturu to Maiduguri. The defense of the defendant was not investigated at all by the NDLEA, which has become a recurrent decimal in this court. It is my humble view that humble but strong view that the failure of the prosecution to thoroughly investigate the defendant's story in his testimony in court that the exhibit belongs to one Sadiq is fatal. See Opeyemi versus State, 1985. Failure to perform such vital duty is likely to lead to a miscarriage of justice, as neither the Sadiq nor the unnamed or unidentified person that gave the defendant the baggage containing the seized exhibit was brought before the court in this case as either as a defendant or witness. So many questions begging for answers. The prosecution did not conduct a holistic investigation of this case, having left out much to be done. The burden of proving that any person has committed a criminal offense is on the prosecution. As I've stated, I keep on reiterating, the standard of proof required is beyond reasonable doubt. See sections 135.1 of the Evidence Act 2011. Consequent upon my findings, above and in line with the decided authorities cited, I hold that the offense of possessing of unauthorized drugs has not been established against the defendant. The prosecution has failed to discharge the onus of proof placed on it beyond reasonable doubt in this case. This is because being a criminal trial, the onus is always on the prosecution, having asserted that the defendant have committed the offenses charged or has committed the offense charged. To prove the assertion beyond reasonable doubt, has the prosecution discharged its burden in this case to entitle it to succeed? In this case, there's doubt in my mind created by the circumstances surrounding the shoddy manner of investigation. Therefore, it is with the above position in mind that I find that I cannot convict the defendant alone for possessing unlawful psychotropic substance while the alleged owners are not brought before the court. This will certainly portray the law as an instrument of injustice and the court as mechanical applicant of Section 19 of the NDLEA Act, under which this case is being prosecuted. The primary duty of the courts of law is to interpret laws and apply them to the facts and circumstances of each case with the main objective of achieving justice and no more. The law should not be made or used as an instrument of injustice in whatever guise. That is why the courts are created and the judges are there to interpret the laws in connection with the citizens for whom the laws are made. In discharging this primary duty of interpretation of laws, the courts and judges are not robots to act on the touch of a button by the prosecution or any litigant for that matter. In other words, courts and judges who mind them are not just there to enforce the law mechanically, but to interpret the law to achieve justice to all the people involved, I so hold. In our criminal justice system, the guilty mind of the defendant is fundamental to criminal responsibility, especially in such offenses, and so the prosecution must establish the guilty mind of the defendant before he can be criminally liable. In these circumstances, I have to resolve the doubt in favor of the defendant, and I so resolved. Consequent upon my findings above, the prosecution has not discharged the prosecution has not discharged the onus of proof placed on it beyond reasonable doubt. In this case, the defendant is entitled to a discharge and he is therefore acquitted. This honorable court admonishes you to stay away from crime or any of its appearances. You are enjoined to stay true to your words and lead an exemplary life, saying that you are a young man with a bright future ahead of you. The 41 bottles of cough syrup with codeine as exhibits is thereby seized and forfeited to the federal government of Nigeria through the NDLEA Yobe State Command. The exhibits shall be returned to the office of the NDLEA to be destroyed. This is my decision.
As the court pleases.
We are most grateful, my noble Lord, for this eloquent judgment. Thank you. We are most obliged, my Lord.
Welcome.
Thank you very much, my Lord. We have learned so much, my Lord, and we were able to overcome our shortcomings. Thank you very much, my Lord.
Thank you, counsel. Call the next case, please.
As the court pleases. Charge number FAC/DM/CR/4/2023 between the Federal Republic of Nigeria versus Garba Alhaji Hassan.
My Lord, the defendant is absent. The defendant.
Representation. Any representation in this case?
Yes, yes, my lord.
If you are ready, we go on to the next. If you are not ready, we go on to the next case.
Yes, my lord. Actually, my lord, the defendant called me this morning that he is on his way coming from Nguru local government. So unfortunately, just a few minutes ago, I tried to connect with him, but I couldn't connect. It couldn't connected. So I think maybe it's network problem. I don't know, Sha. So in view of this, my
Please
lord,
speak
we are
properly.
even tomorrow.
Counsel, can you hear me, defense counsel?
Yes, yes, my lord, I can hear you, my lord.
You better sit up properly and talk to the court properly. I don't like this share business that you have started. I've never seen you in my court, so you better act up. And your gadget is turned sideways. Why is your, can you turn your gadget so that I see you seated properly?
Yes, my lord.
What is your name? I said representation, you just kept quiet.
Sorry, it's network, my lord. I can hear you now.
I said, what is your name?
May it please, my lord, my name is A.A. Musa, and my humble appearance is for the defendant, my lord.
Continue. Continue.
Is there only one counsel in this case? Only one counsel?
Yes, my lord.
Yes. Go ahead then.
My lord, the reason being the defendant, why is that he called me this morning that he's on his way from Unguru local government. So unfortunately, just a few minutes ago, I tried to reach him, but his line, it wasn't connecting. So in the interest of justice, my lord, we humbly apply for short adjournment. Even tomorrow, we are ready for that, my lord, to confirm his whereabouts.
Registry of court.
My lord.
Give me a date.
As the court pleases. My lord, 19 July.
Thank you.
Court.
rule in this matter is called. The defendant is not before the court, as well as the prosecuting counsel. This matter is hereby adjourned to the 12th day of October, 2023.
As court pleases. Thank you, my lord.
Call the next case. Registry of Court, call the next case.
Charge number FSC/DM/CR/28/2022 between the Federal Republic of Nigeria versus Kaka Ali Lawan. Yes, my lord, the defendant is here present in court. We are now together with the defendant in court, my lord.
The presentation.
Respectfully, my lord, my name is Usman Bamala. My humble appearance is for the complainant.
No defense counsel?
My lord, we are before the court, my lord.
Then why are you keeping quiet?
With respect and humility to my lord, my name is U.L. Lukman, and my respective appearance for the defendant, my lord.
Ruling.
As court, please.
The defendant in this case is Kaka Ali Lawan, who is standing trial before the court on a one-count charge, number FSCDMCR 28/2022, dated April 2022 and filed 29th April 2022 by the National Drug Law Enforcement Agency, NDLEA. The charge reads that you, Kaka Ali Lawan, male adult of Kalari, Damaturu Ward, Maiduguri, Borno State, on 13th day of April 2022, along Potiskum Damaturu Road, Damaturu, Yobe State, within the jurisdiction of this honorable court, without lawful authority, found and arrested in possession of 3.5 kilograms of tramadol tablets, suspected to be psychotropic substance, a substance similar to cocaine, heroin, and LSD, and thereby committed an offense contrary to and punishable under Section 19 of the National Drug Law Enforcement Agency (ADCAP) N30 laws of the Federation of Nigeria, 2004. The defendant pleaded not guilty to the charge when he was arraigned on the 11th day of May, 2022. The prosecution called two witnesses, PW1 and PW2, both officers of the NDLEA. Now, when the court is called upon to determine whether a no-case submission should be sustained or failed, it is not an occasion when it should indulge itself in a long ruling, but must look at the indictments vis-a-vis the evidence laid in concrete terms in order to come to a decision as to whether or not the defendant should be called upon to enter his defense. In doing this, the court must bear in mind that by Section 135, Sub 1 of the Evidence Act 2011, the burden to prove and establish a prima facie evidence to support the ingredients in the indictment as contained in the one-count charge dated 28 April 2022 and filed 29 April 2022 lie on the prosecution, and the defendant is not required by law to put in evidence to prove his innocence. Concomitant to these legal precepts is the fact that where there arises any doubt by disjointed links and gaps in the evidence led by the prosecution, the doubt is by law must be resolved in favor of the defendant. I've read the address of counsel on the no case, defense counsel on the no case, and the response thereto. The prosecution counsel in his oral reply in court submitted that they have not filed any reply, which is as a result of having perused the content of the no case submission filed by the defense counsel, and is of no contest, and urge the court to discountenance the no case submission filed by the defendant. When I read through the submissions of defense counsel, I consciously warned myself that a ruling on a no case to answer submission must be as brief as possible. I refer to the Supreme Court decision in Ajiboye versus State. Counsel, can you hear me?
Yes, my lord, we can hear you.
Yes, my lord, we can hear you.
Thank you. Ajiboye versus State, 1995. His Lordship, the Honorable Justice I.L. Kutiki JC, as he then was stated, I quote, "It must be recognized that at the stage of no case submission, the trial of the case is not yet concluded. At that stage, therefore, the court should not concern itself with the credibility of witnesses or of the weight of their evidence, even if they are accomplices. The court should also, at this stage, be brief in its ruling, as too much might be said, which at the end of the case might fetter the court's discretion. The court shall again at this stage make no observation on the facts. This is because the decision of the court is guided by established legal and judicial principles, which both counsel have ably, in my view, espoused. It is not an occasion when the court will subject the evidence led to a detailed, perhaps microscopic analysis and forensic dissection, and or to begin to ascribe probative value to the testimonies of the witnesses called by the prosecution. All the court is required to do is to reflect on the indictments with which the defendant is charged, evaluate the evidence, and to see whether the said evidence constitutes legally admissible evidence that prima facie established the charge against the defendant in relation to the ingredients or elements of the count. The relevant provisions of the law portion to which the defendant has been indicted is Section 19 of the NDLEA Act, Cap N30 Laws of the Federation of Nigeria, 2004. That section provides as follows: that any person who without lawful authority knowingly possesses the drugs popularly known as cocaine, LSD, heroin, and or any other similar drug shall be guilty of an offense under this act and liable on conviction to be sentenced to imprisonment for a term not less than 15 years and not exceeding 25 years. This is the provision of the law which is meant to guide the prosecution on the one count indictment against the defendant as contained in the charge. The ingredients of the offense created by the above quoted Section 19 of the NDLEA Act are possession, which is unlawful, knowledge of the drugs being in the possession of the defendant, and the drug possessed is confirmed to be cocaine or any similar drugs. In this case, the defendant is charged of being in unlawful possession of 6 rolls of tramadol tablets of 10 packages amounting to 60 packets, a controlled drug without lawful authority. The trial of the defendant effectively began on 22nd day of September 2022 with the prosecution calling 2 witnesses, Mohamed Rabi Sultan and Davis Bambis, both of whom are NDLEA officers attached to NDLEA Damaturu Yobe State Command. Mohamed Rabi Sultan, as PW1, testified that he is the exhibit officer at NDLEA headquarters, whose duties include receiving exhibit arrested with suspected offenders, testing drug exhibits, weighing them, keeping custody of such exhibits, and also testifying in court in respect of same. The said witness identified the defendant by name and testified that on the 13th day of April 2022, the defendant was brought to his office with recovered exhibits comprising of 6 rolls of tramadol tablets inside a white sack by Davis Bambis and Charlie John. Mr. Davis Bambis is the second witness who is hereinafter referred to as PW2, who identified the defendant by name and testified that on the 12th day of April 2022, at about 7:30 hours, the witness was among the team of NDLEA operatives at Potiskum, Damaturu Road in a search operation. During the search operation, a Golf vehicle coming from Kano to Maiduguri was intercepted and searched, where a carton at the boot of the vehicle, which was a way bill with the phone numbers of the receiver, wherein The driver was detained and a call was made to Maiduguri, to the receiver of the waybill, who is Kaka Ali Lawan, the defendant, where he was arrested in Maiduguri and brought to Damaturu on the 13th April 2022. Whereupon the driver identified the defendant as the recipient of the waybill, the witness testified that the defendant claims and accepted ownership of the waybill, that the carton was opened in his presence, and it was discovered that the carton contains tramadol tablets, which was field tested in the defendant's presence by the exhibit officer, and it weighed 3.4 kilograms. The defendant therefore signed some exhibit forms, and other witness officers also signed the exhibit forms, and later the defendant volunteered his statement. Freely as the original owner and recipient of 3.4 kilograms of tramadol, that PW2 testified that he witnessed the above mentioned facts. Now, the occasion, as stated earlier, to rule on a no-case submission is not one in which the court will bother itself with ascribing or ascription of probative value to the testimonies of the witnesses called by the prosecution, or the weight to be attached to the evidence and exhibits tendered. To do this will amount to according the defendant an unfair advantage in the adjudicatory process. A ruling on a no-case submission must only assess the evidence led, whether they are legally admissible, to establish a prima facie case in which the defense person should be called to enter his defense. I have read the loan count. The question is whether the evidence adduced had been so discredited by cross-examination of the prosecution's witnesses so much that what may be left of the evidence have become so badly fractured that it will be ideal, judicially speaking, to call upon the defendant to enter into his defense, or at best to offer explanation on what may be left of the degraded evidence, which prima facie may no longer in law support the indictments or link the defendant with the offense charge. By my, excuse me, by my assessment of the testimony of the lone witness called by the prosecution, testimony of the witnesses called by the prosecution, and the documentary and real exhibits tendered, I'm unable to reach or return a verdict, and that the evidence adduced by the prosecution has been so badly discredited, perhaps severely fractured, that it will amount to sheer judicial affectation to decline to require the defendant to enter his defense. At the stage of ruling on a no-case submission, the court is enjoined on the authorities of the appellate court's decisions to refrain from making prejudicial findings on the facts, or to dwell on the assessment of the credibility of the witnesses, or begin to ascribe probative value to the testimonies of the witnesses, as I stated earlier. The primary duty of the court is to ascertain if the evidence laid is admissible and believable, if they link and connect the defendant with the indictments in the criminal charge. It is my view that the court can only do this if it was already writing its judgment, by which, on account of its findings, it would probably reach a verdict to discharge the defendant. The substantial part of the forensic analysis of the defendant's counsel did in his written address is such that unless the court consciously warned itself, may invariably occasion a judicial slip into the terrains which the several decisions of the appellate courts have declared as a no-go area. At this stage, when the court is saddled with an application brought pursuant to Section 303, sub-3 of the Administration of Criminal Justice Act 2015, In conclusion, it is my view that a dispassionate consideration of the evidence adduced by the prosecution, especially in relation to the evidence of both PW1 and PW2, when read and extracted with related exhibits, which includes exhibits NDLEA KAKA 1A, 1B, 1C, 2A, 2B, 2C, and NDLEA KAKA 3, the prosecution, in my view, has adduced prima facie evidence which link the defendant with the indictments in the one-count charge dated 28th April and filed 29th April, and the defendant shall be 2022, and the defendant shall be required to enter his defense. This appears, in my view, should require a form of explanation from the defendant as a defense in order to disprove the case of the prosecution. This shall be the ruling of this court on the no case to answer submission made by the defense counsel. I will want to know what dates are convenient for both counsel for the defense to begin their defense on the long count on which there appears to be a prima facie evidence establishing the commission of the offense therein stated. This honorable court hereby adjourns this matter to the 10th registry of court. Give me a date.
12th October, my lord.
This honorable court hereby adjourns this matter to the 12th day of October 2023 for the defendant to enter his defense. Meanwhile, the defendant is to continue to enjoy the bail granted him by this court till the next adjourned date.
As the court pleases.
Yes, thank you. Call the next case.
As the court pleases. Charge number FSC/DM/CR/7/2022 between the Federal Republic of Nigeria versus Abdurrahim S. Munkaila.
Present. My lord, we are here in Correctional Center together with the defendant Abdurrahim S. Munkaila. Present.
Yes, representation.
My lord, MS Nasir, ACSC, and I'm humbly appearing for the prosecution. Thank you.
With profound respect and humility to our lordship, my lord, I'm DI in Dahi for the defendant. Thank you.
Ruling.
As
As
court
court
pleases.
The trial of the defendant hearing, Abdurrahim S. Munkaila, has begun in earnest, and on the 18th May 2022, while PW31 Ganda was given evidence in examination in chief, the learned counsel to the prosecution, MS Nasiru, sought to tender through the said PW3 the statement made by the defendant to the National Drug Law Enforcement Agency. Fortiscum Correctional Center, can you mute your microphone?
No. Yes, my lord.
Okay, thank you. The learned counsel to the prosecution, MS Nasru Esquire, sought to tender through the said PW3 the statement made by the defendant to the National Drug Law Enforcement Agency, NDLEA, in the course of investigation. National Counsel, the defendant, D.I. Indahi, objected to the tendering of the document, contending that the statement dated 25th day of January 2022 has not been voluntarily recorded, that it was made under duress and promise, and that the statement was not interpreted to the defendant. And in view of the objection raised by the defense on the issue of involuntariness of the defendant's statement upon his arrest, counsel applied for trial within trial, which the court granted. The trial within trial was adjourned severally as a result of the challenges faced by the Potiskum Correctional Center in producing inmates for trial. Therefore, the absence of the defendants stalled the trial. The trial within trial eventually commenced on the 10th day of November 2022, whereupon the prosecution, in proof of the voluntariness of the said confessional statement, fielded two witnesses, namely TPW1 and TPW2, and let him in evidence to rebut the allegation of the defense. While the defense counsel at the next adjourned date fielded the defendant as DW1, TDW1 as their sole witness. Now, trial within trial is a verdict that is, trial within trial is still a criminal trial that may best be described as a mini trial within trial. It is to ascertain the admissibility of the confessional statement of an accused person. See Body Shade versus Federal Republic of Nigeria, 2012, in support and in rebuttal of an allegation that a statement was not made voluntarily. Once an objection is raised on the voluntariness of an extrajudicial statement, the court must call for trial within trial. This is because a confession in a statement made by a defendant which was not freely and voluntarily made cannot be admitted in evidence. See Body Shade versus Federal Republic of Nigeria, Supra, and Oje Gele versus State, 1988. In the case of Sani Abdullahi and others was the State, 2009 LAPLR, the issue was whether the voluntariness of a confessional statement will be tried with a trial within trial. BADA JCA held that it is settled that an accused person confronted by the prosecution that he made a statement voluntarily must make his stand clear. Either that he did not make the statement, in which case the court will rule after the submission by both parties, or that it was not voluntarily made due to some duress, undue influence, or coercion. In the former case, the court may admit the statement in evidence and assess its weight in the final decision. In the latter case, the voluntariness must be tried by what is called trial within trial. And if found to have been made voluntarily, it is admitted in evidence. If not, it is rejected as evidence. The above position was reinforced by Ono Genjesi in Rashid Lasisi versus the State, 2013, LPLR, wherein my lord held that, I quote, the procedure of a trial within trial is not designed to determine whether an accused person made the statement, but whether he made it voluntarily. In other words, an accused person must admit making the confessional statement before he could raise the circumstances in which the confessional statement was made by him. To resolve the issue, this court will refer to the testimony of the prosecution witnesses, TPW1 and TPW2, as well as the defendant himself as defense witness, TDW1, in the trial within trial for more elucidation and to ascertain the truth. The TPW1 testified thus: my names are Babagana Bukar Ganda. I am 42 years and a Muslim, a public servant working with NAPTIP for 14 years, now with the Yobe State Command, an active senior intelligence officer whose schedule of duties is operations and investigations. That the way and manner the statement of the defendant was recorded on the 25th January 2022 was that a suspected case of sexual exploitation reported to NAPTIP Yobe State Command by one Hafsat Mohammed, who happens to be the mother of the victim. I was detailed to carry out the investigation into the case on the instruction given by the state commander in person of Saleh Zakka. I took the defendant to the interrogation room of the command asked him to sit, and I asked him the language he understands. He said Hausa. I informed him the allegation launched against him in Hausa language, which he understood and admitted. Then I brought out a statement sheet, administered word of caution, and asked him if he can volunteer his statement. He said he cannot read or write and authorized me to record his statement, which I did. I have recorded the statement in Hausa language and read the statement over to him, to which he affirmed it was his statement. He signed and thumbprinted on the statement, and I wrote my name. Then I translated the Hausa version to English language and also read the translated version to the defendant. He agreed that yes, it is his statement. He signed and thumbprinted, and I wrote my name and signed. We recorded the statement without any promise, threat, or torture. I took both the statement and the defendant to my superior, who is the state commander in the person of Saleh Zakar. He read the statement to the defendant, who agreed that it was his statement, and he countersigned. The interrogation was at 13:00 hours, and that the defendant was healthy enough. During cross-examination, the defendant counsel asked the TPW1 whether at time of recording the statement, the defendant's lawyer or relatives were present, to which TPW1 responded that it was recorded in the presence of his friend or brother, that someone was there at the recording and that he has no business with the person that came together with the suspect, and that in the course of taking statement, it was a question and answer session. During re-examination, the witness was asked to elaborate more on the last question, asked to which he replied that he only asked if he has a lawyer, to which the defendant said he doesn't, that he only came with a friend, and that he asked preliminary questions and then allowed the defendant to flow. The TPW2 testified thus: my names are Saleh Zakar. I'm 49 years old and a Muslim, a public servant working with NAPTIP for 12 years. Now with the Yobe State Command, I'm the state commander of NAPTIP. On the 25th January 2022, one Hafsat Muhammad of 1 Million Road, Damaturu, brought a complaint before our office that her daughter Fatima Mohammed was sexually exploited by one Abdurrahim Munkaila of Specialist Hospital Damaturu, of General Hospital Damaturu, which I directed my head of intelligence and operations, one Babagana Bukarganda, to go ahead and investigate the matter. On the same date, 25th January at about 13:00 hours, the defendant was brought to my office by Ganda with his statement, which I went through and read over to him, his understanding, and asked him, is that his statement? And he affirmed. I asked again, is there any addition or subtraction in the statement? He said no. I asked, was the statement taken under duress or was there any promise by my officers? He stated no. I then countersigned the statement. During cross-examination, the defendant counsel asked the TPW2 whether he was there when the statement of the defendant was taken, and the witness answered in the negative, to which he was further cross-examined that since he was not there, even if the defendant was threatened or induced, he will not know, and he replied no. The prosecuting counsel thereby closed his case. The matter was adjourned severally to enable the defendant to be produced from the Potiskum Correctional Center. He was eventually produced in court on the 27th March 2023, which enabled the defense, the counsel to the defendant to open their case, whereby the defendant as a sole witness was called, where he testified thus: my names are Abdurrahman Samaila Munkaila. I'm 28 years old, a Muslim, and a security man at the General Hospital Damaturu since 2016. I live in Damaturu, Bindigari, Ward, Line, Pata. I was asked Where I came from during the statement taken, I answered Damaturu was where I was asked where I was born. I said Katagum. My names, my parents' names, and my older siblings, etc. It took him about 10 minutes to write, and he gave me a paper to sign or thumbprint. I then asked him to assist me with my phone to enable me call my brother to tell them the situation I was in. I was kept for 18 days, then sent to prison. That is all I know. And when asked whether anything happened before, which he has not told the court, the TDW1 answered yes. Before I thumbprinted, he held my hand with a biro and forced me to write and told me that he has finished his investigations, that I am not at fault. That was what happened that I know between us. During cross-examination, TDW1 confirms his name, his state of origin, his parents' name, the schools he attended, his place of employment, and when further asked whether he volunteered a statement at NAPTIP office, he answered that he was forced. The jury recording of the statement, he was called in an office with TPW1, and he gave a statement about his background, but he does not know the rest. And when further cross-examined that, how can he reconcile the fact that he gave all the information in the statement, but he's again saying that he does not know the rest? The TDW1 answered that he cannot remember what happened after he forced a biro on my hand and thumbprinted. Thereby, the defense closed his case in respect of the trial within trial, and counsel submitted to court that he does not intend to address the court, but leaves it at the discretion of court, to which the prosecuting counsel also submitted that they also waive their address. Now, an address by counsel are designed or tailored in line with the evidence on record to assist the court. In this case, both the prosecution and defense counsel deem it fit or deem it wise to waive the right to both written and oral address on the facts in contention in the trial within trial. It is my humble view, my humble but strong view, extrajudicial statement made by an accused person or defendant to the law enforcement agents like the police, NDLEA, or NAPTIP, as in this case, containing an assertion or admission of guilt and showing that the defendant participated in and is culpable for the commission of the offense for which he has been charged, must be voluntarily made, positive, unequivocal, and must amount to admission of guilt. And that is when such a statement can be called or termed confessional statement. The law is settled that it is the prosecution that has the onus to prove beyond reasonable doubt that the statement of the defendant was voluntarily made. See Section 29, Sub 3 of the Evidence Act 2011. Several judicial authorities from the appellate courts are also in agreement that it is the prosecution that bears the burden of proving the voluntariness of a confessional statement. The standard of that proof is beyond reasonable doubt, as in all criminal cases. The prosecution witness, PW2, testified as to the way and manner the statement of the defendant was recorded on 25th January 2022, that he was cautioned and he said he cannot read or write and authorized him to record his statement, which he did. Having recorded the statement in Hausa language and read over the statement to him, to which he affirmed it was his statement, the defendant signed and thumbprinted while the recorder wrote his name. Having translated the Hausa version to English version and also read the translated statement to the defendant, to which the defendant agreed that it is his statement, he signed and thumbprinted while the recorder signed his name, that the statement was recorded without any promise, threat, or torture. During cross-examination, the defendant counsel asked the TPW1 whether at time of recording the statement, the defendant's lawyer or relatives were present, which the TW1 responded that it was recorded in the presence of his friend or brother, that someone was there at the recording, and that he has no business with the person that came together with the suspect, and that in the course of taking statement, it was a question and answer session. During the examination, the witness was asked to elaborate more on the last question asked, to which he replied that he only asked him if he has a lawyer, to which the defendant said he doesn't, that he only came with a friend, and that he was asked a preliminary questions and then allowed him to flow. TDW1 testified, I reproduce again, I was asked where I came from during the statement taken. I answered Damaturu, but was born in Katago. I told him my names, my parents' names, and my older siblings, etc. It took him 10 minutes to write, and he gave me a paper to sign or thumbprint. I then asked him to assist me with a phone to enable me to call my brother or to tell him the situation I was in. I was kept for 18 days, then sent to prison. That is all I know. And when asked whether anything happened before, which he has not told the court, the TDW1 answered, yes, before I thumbprinted, he held my hand with a biro and forced me to write and told me that he has finished his investigations, that I am not at fault. That was what happened between us. This assertion of the defendant's counsel that the defendant's statement was not taken voluntarily, but was induced by promises to retain his employment and threats of being imprisoned for life by the nature of the offense, and that once the defendant admits, he might condone and pardon him. As such, he spent 19 days at detention before being arraigned in court. And that secondly, the defendant, not being literate in English language, does not know the contents of what was in his statement. This has not been rebutted during cross-examination. This has been rebutted during cross-examination, as stated above. The defendant did not elaborate on how he was forced, promised, or induced. He was prompted before he informed the court that he held my hand with a biro and forced me to write. The testimony of both the PW1 and PW2 that the recording of the statement was corroborated by the TW1 himself during cross-examination. TW1 confirmed his name, his state of origin, his parents' name, the schools he attended, his place of employment. And when further asked whether he volunteered a statement at NAPTIP office, he answered that he was forced. And he gave a statement about his background, but he does not know the rest. And when further cross-examined, that how can he reconcile the fact that he gave all the information in the statement, but he is again saying he does not know the rest. The TDW1 answered that he cannot remember what happened after he forced a biro on my hand and thumbprinted. This honorable court holds that from the above testimony has not created doubts in my mind as to the voluntariness of the statement taken into account, that there was no duress, false promise, or inducement that occurred during the recording of the statement of the extrajudicial statement complained about by TDW1. From my evaluation of the evidence before this court in trial within trial, the confessional statement was made voluntarily without inducement, threat, or promise from a person in authority. Therefore, there does not exist cogent reasons to doubt the voluntariness of the statement. This honorable court, by the above analysis, determined that the prosecution has established that the extrajudicial statement of the defendant was made voluntarily to the extent I'm satisfied and feel sure about it after hearing evidence on either side, bearing in mind the contested statement was not obtained by duress or promise as a question of facts relevant to the determination of the evidence as to the manner in which it is made at the trial within trial. As for the testimony of the defendant in court, the law and precedents have made it clear that a retracted or challenged confessional statement does not really necessarily exonerate a defendant from the commission of an offense. The extrajudicial statement of the defendant dated the 5th day of January 2022 sought to be tendered by the prosecution, which was objected to by the defense and for which this court conducted a trial within trial for its admissibility is hereby tendered and marked exhibit NDLE Naptib Abdurrahim 1. Consequently, the objection of the defense is overruled and it is hereby ordered that this trial proceed with the continuation of the examination in chief of PW3. This matter is hereby adjourned to the 12th day of October 2023. This shall be the ruling of this court.
As the court, please.
Thank you. Please, can you call the next case?
As the court pleases. Charge number FSC/GM/CR/14/2018 between the Federal Republic of Nigeria versus Hussaini Mohammed.
Hussein Mohammed. Okay.
Yes.
With the greatest respect and much honor, my lord, Usman Bamala, my humble appearance is for the complainant.
Any counsel for the representation for the defendant?
Yes, with the greatest respect, my lords, I'm M. Lamido. My humble and respectful appearance for the defendant. My lords, the positions of the case is for defense and subject to the overriding conveniences of the court. We are ready, my lord.
My lord, we are equally ready.
Yes. Counsel, defense. Is the defense your first witness?
All right. My lord, the DW1 is hereby present and we are ready to proceed.
Where's the defendant? Just a minute. Where's the defendant?
Yes, my lord. The defendant, we are together with him here in court, my lord.
Okay. Yes.
All right. Defense, tell the court your name.
The court, please. Let me affirm myself, my lord. I, Mustafa Abana, do solemnly affirm to interpret court proceedings from English to Hausa and vice versa to the best of my ability. So help me God. Za ka ɗauki rantsuwa akan wannan shari'a naka da ake yi, duk abin da za ka faɗi gaskiya za ka faɗa. Ka ɗaga hannunka yanzu na dama, duk abin da na faɗi sai ka faɗi a bayana. Na ce ni sai ka ambaci sunanka. Ni ka ɗaga murya sosai.
Hussaini Mohammed.
Shaida da zan bayar. Faɗa.
Shaida da zan bayar.
A wannan shari'a.
A wannan shari'a.
A wannan kotu mai alfarma.
A wannan kotu mai alfarma.
Gaskiya zan faɗa.
Gaskiya zan faɗa.
Ba wani abu face sai gaskiya.
Ba wani sai gaskiya.
Ya Allah ka taimake ni.
Ya Allah ka taimake ni.
Shikenan, to gyanuka. Yes, my lord. DW1 has been duly affirmed. He is male, adult, and a Muslim, my lord.
Yes, go ahead, counsel.
Thank you, my lord. Mr. Witness, tell your names to the court again.
Ka gaya ma kotun nan cikakken sunanka.
Hussaini Mohammed.
Your age?
Shekarunka nawa?
Shekaruna
60 years of age.
Where do you live?
A ina kake da zama?
Ina garin Gada.
He lives in garin Gada.
Particularly which local government?
A wane karamar hukuma? Wane local government kake kenan? Wannan
Garin Gada na wajen Gaidan ko na Gadan Jannan ko Gaidan?
Yunusari.
Is under Yunusari local government.
Thank you. Your tribe or religion?
Me da kabilanka da kuma addininka?
Fulatani.
Addininka fa?
Addinina Musulunci.
He is Fulani by tribe and his religion is Islam.
All right. I hope you know why you have been here before the court.
Ka san dalilin da yasa kake wannan gaban wannan kotu? He say he don't know why he is in court.
You must have known. Okay. Did you know that you have been trials on allegations of 33.1 of cannabis sativa before the court?
Yace ka san cewa kana fuskantar tuhuma akan zargi na mallakan kilogram 33.3 na busasshen ganye wanda ake zargin wannan tabar wiwi ce.
Counsel, I think it is 33.1 of psychotropic substance and 900 grams of cannabis sativa. Make your record clear, please.
33.1
of psychotropic substance.
Yes.
And 900 grams of cannabis.
Anan gaban kotu kana fuskantar tuhuma na kilogram 33.1 da kuma grams 900 na busasshen ganye wanda ake zargin tabar wiwi ce. Kana fuskantar tuhuma a wannan kotu, haka ne?
Ba haka.
He say it is not true.
Okay. And now the prosecutions called the total numbers of witnesses to testify in respect of the allegations against you. Now it is your turn to defend yourself in respect to that. What will you tell the court on the allegations?
Yace shi mai gabatar da kara ya kira shaidu masu dan dama saboda ainihin su tabbatar da zargi wannan tuhuma da ake yi maka a wannan kotu, a wannan laifi da ake tuhumanka a kotu. Yanzu kuma lokaci ne wanda kai zaka kare kanka. Me zaka faɗa ma wannan kotu yanzu? Ka daga murya a jika.
Sharri ne wallahi ina roƙon kotu ne dai ya sallafe.
He said the allegation is not true. He's just urging the honorable court to discharge him.
Tell us what you know in respect of the allegations against him. What happened to him? What happened to him that he was being arrested? What happened? You should tell the court what he knows, what he knows.
Ka gaya ma wannan kotu dangane da zargin da ake maka, ka faɗi me ka sani akan wannan tuhuma da ake maka, gaya wa kotu.
Yes, he was arrested.
Yes, counsel, continue.
Yes, he was arrested by the NDLA officers. Where was he arrested and what happened at that time? He should tell the court what actually happened.
Okay. Su wayannan ma'aikata na hukumar na masu hana sha da safara da miyagun kwayoyi wato NDLEA sun kama ka. Da suka kama ka kuma sun kawo ka kotu. Me ya faru a wannan yanayin da kama ka da suka yi da kuma?
Yes, in that garin Gada Yunusari, what happened there?
Me ya faru a wannan garin Gada da ka ambata shine garin ka? Me ya faru tsakaninka da wannan ma'aikata?
Yaro na farko su.
Ka daga murya a jika. Magana a hankali hankali.
Kama yaro na ne na je a nan ne muka samu sabani. Wani ne ya yi min
dunkulallen abu ya kai gidana kusa da gidana ya ajiye ban sani ba. Man ban san da shi.
They caught who?
Wa suka kama? Ka fada wa suka kama?
Just a minute, counsel. I need him to start all over, but tell him to speak slowly because he is being recorded. So he should speak slowly, one after the other.
As court pleases.
Yes.
Kotu tana so ka koma baya ka fara gaya wa kotu daga farko abin da ya faru tsakaninka da ma'aikatan NDLEA a garin Gada din. Sannan in ka yi magana kana ɗan tsayawa saboda kotu tana rubutawa. Ka fara yanzu me ya faru ka ɗaga muryanka in ka yi magana kaɗan sai ka tsaya sannan ka ci gaba in ka faɗi kaɗan sai ka tsaya ka ci gaba haka. Ka fara magana yanzu.
To farko yaro na ne da wani yaron su.
A ɗaga murya sosai. Ci gaba.
Irin boyi nasu yana neman matar yaro na sai suka yi faɗa tsakanin su.
To ka tsaya haka. Kana ɗaga murya sosai da tiro.
Yes.
Ci gaba.
Sai suka je suka kama yaro na da suka kai shi suka ringa dukansa na ɗauki polis na kai musu.
Haka. Yes, ci gaba.
Yawa shi ne suka ce min na ce faɗa wannan ba nasu ba ne ba na harkan polis ne muka je muka karbi yaro na to daga baya aka yi min wani.
What was his last sentence?
He said he told them that fighting is not a duty of police. They went and get the child from the police custody and come back home. Haka kace ba? Ka karbo yaron ka zuwa gida ko?
Na karbo yaro na shi suka ji haushi na suka yi min wannan harka.
Abun NDLEA ko abun police?
Abun NDLEA.
Sorry, my lord, he's from the NDLEA. He gets his child. Abun suka kamo da ka samu yaron na ko?
Na karbo ni da police muka je na karbo yaro na to daga baya suka yi min wannan din abu.
So NDLEA.
Suna jin haushi na
Shikenan. She can't see this. Ci gaba.
Shi ne suka yi min sharrin wannan din abun. Suka ce ai nawa ne meme da sauransu suka kamo ni suka zo suka jefa. Don sun rasa yadda za su yi suka yi min sharrin wannan.
Yes, continue.
Ci gaba.
What happened when they were when you are caught by them?
Bayan sun kama ka, NDLEA sun kama ka, sai me ya faru?
Shafawa suka yi da ni Damaturu. Suka zo suka rike ni kona 6.
Yes, can you?
Yes, when they detain you for 6 days, what happened later on?
Bayan sun tsare ka na kwana shida, sai me ya faru daga nan?
Sai aka ɗauko ni aka kawo ni kotu. Kuma an tambaye ni abun da na sani na faɗa, wannan wanda na sani na faɗa yanzu shi na sani.
I did not get that.
He say after they detain him for 6 days, they
Yes.
arraigned him before the court. And all he tell now is what he told them at the first time.
In your testimony before the court, you said that your son was being arrested by the NDLA officers. What did he do that he was being arrested?
A cikin shaidan da ka bayar yanzu ka faɗi cewa NDLEA sun kama ɗanka, me yayi wanda ya sa suka kama shi?
Faɗa yayi da boyinsu akan yana neman matarsa. Da aka kama aka kai shi wajensu. Shine na ce to wannan kes ɗin ba naku bane ba, na polisawa ne, na tafi da polis ya karbi kes ɗin. Muka je muka kashe kes.
If I get you right, when you are detained for 6 days and you are being arraigned by the NDLA officers to the courts, is that all what you know, or you want to add something?
Ya ce in ya fahimce ka daidai, bayan sun tsare ka na kwana shida, sun kawo ka nan kotu, su NDLEA kenan. Shine dukkan abin da ya faru, ko dai kana da wani abu da zaka ƙara faɗa a kai?
Ba wani abu, abun da na faɗi wannan shine kawai na sani.
Shikenan.
All right, now, what do you want courts to do for you?
Yanzu me kake so wannan kotu mai alfarma ta yi maka?
Ina son kotu ya sallame ni kawai.
Kana son kotu ta sallame ka?
Na roƙi kotu ya sallame ni.
Shikenan, kotu ya ji.
My Lord, that's all for my witness. The DW1 is the end of our defense, my Lord.
Cross-examination?
Yes, my Lord, I have some very few questions of cross-examination. My Lord, I wish to proceed, my Lord.
Go ahead.
Thank you. Mr. Muhammad Hussaini, Mr. Hussaini Muhammad.
Ya ce maka sunan Hussaini Muhammad yake ma magana. Shi mai gabatar da ƙara.
Tell the court that the prosecution want to make a cross-examination to him since we close our defense.
What do you say, counsel?
Abana, he's going with his own side.
Since we close our
do inform counsel. Counsel, tell this the witness that the defense counsel have closed their case and the prosecuting counsel is going to cross-examine him based on what he has informed the court just now.
As the court pleases. Shi lawyer mai kare ka gane ko? Yanzu haka ya gama duk bangarensa abin da zai yi na kare ka. Yanzu shi kuma shi lawyer mai gabatar da kara zai yi maka wasu tambayoyi akan maganan da shaidan da ka bayar yanzu haka a kotu. Ka fahimta ko? Shine tambayoyin da yanzu zai maka kenan mai gabatar da kara. Ka daga murya sosai a jika.
Mr. Muhammad Hussaini, you are enough to be a father or even a grandfather to me.
Ya ce kai Usaini Muhammad ka kai ka zama mahaifi a gare shi ko ma kakansa ma shi wannan mai gabatar da ƙara.
Zai yiwu dai.
Ka ɗaga murya a jika da tijo.
Haifuwa dai na haife shi.
To, ya ji.
And I believe you will be willing to tell the truth if need be.
Kuma ya ce ya san cewa kana da niyan ka faɗi gaskiya idan buƙatan hakan ya taso.
Ina so.
Kai magana a jika da tijo.
Ina so.
Thank you. The cannabis sativa that was found in your possession, what are you doing with it?
Wannan ganyen busasshen ganye da ake zargin tabar wiwici ne da aka samu a wajen ka, me kake da shi?
Ani ba a samu tabar wiwi a wajena.
Ka ɗaga murya a jika.
An samu tabar wiwi a wajena ba.
Where did they find the cannabis sativa?
Just a minute, counsel. I need to.
Sorry, my lord. Sorry.
He said it was not found in his possession.
Yes, my lord.
Yes.
Then where was it found?
Ina aka samu wannan wiwi din to?
Ban san inda suka samu ba, ni na ga a hannunsu dai sun ce nawa ne. Na ce ina kuka samu, ni ban ba ku a hannuna ba, ina kuka samu taban wiwi kuma wannan a wajena.
Thank you very much. You raised an allegation that you said one boy of NDLEA. So I want to understand that boy. Is it a staff of NDLEA or those who just a volunteer?
Ya ce ka yi zargin cewa akwai boyi-boyinsu wanda suke a dalilinsa ne aka kama ɗanka. Yana so ya san me boyi-boyin nan, ma'aikacinsu ne na NDLEA ko dai wani mai taimaka musu ne haka?
Iri wani mai taimaka musu ne.
Thank you very much. And when you reported the matter to the police and police got involved, and later on NDLEA, as you allege, NDLEA framed you as you claim, then why not your son, who is the body of contention?
Ya ce kamar yadda ka faɗi cewa shi wannan NDLEA sun kama ka, kamar yadda ka zargi cewa sun kama ka ne a dalilin wannan ɗanka ɗin suka tsare ka a wajensu, daga baya police abinan sun tsare ɗanka, daga baya ka kira police suka zo suka shiga cikin lamarin suka karbi kes ɗin, sannan kai kuma suka kama ka daga baya kamar yadda kai musu zargi haka. Sai ya ce to me yasa ba a kama ɗanka ba wanda shine jigon wanda ake wannan shari'a akai?
To ni din ne ai suke jin haushi na, tunda ni na kai musu police din ba yaro na ba.
Shikenan sun ji.
Thank you very much. You will agree with me that your son, when the allegation that the said boy is dating his wife, your son did not report the matter to the police.
Ya ce za ka yarda da shi cewa lokacin da ka ce wai shi wannan boyi wanda kake faɗa cewa ɗanka suna neman yarinya ɗaya da ɗanka, har aka kama shi, me yasa baka je ka faɗa ma police ba wannan lokacin?
Your son.
Shi ne na faɗa masa ai muka je.
Your son did not report.
Asil? Sorry?
Your son did not report the matter to the police.
Me yasa ɗanka bai je ya kai wannan magana zuwa gaban 'yan sanda ba?
To police ɗin da na kai babban mutum ne shi ma. Ba yiwuwa mu sai za mu tallaka shi mu sake yin wani
It's okay. I am interested.
Yeah, just a minute, Council.
Oh, sorry, my lord.
Yes.
Madam Muhammad Hussein, how much is a wrap of cannabis cost in your area?
Yace nawa ake sai da kullin wiwi da ake a asalin garinku?
Ban sani.
Objection, my lord. My lord, I'm objecting this question. I'm objecting this question, my lord.
Sustained.
As God pleases.
As the court pleases.
Madam Mohammed Hussein, in the course of your examination in chief before this honorable court, you made mention that nothing was found in your possession. That was what you said. Apart from you, do you have any other witness to corroborate what you are saying before this honorable court? Or what you just said, sorry?
Yace a lokacin da aka yi maka tambayoyi na farko, ka faɗi cewa NDLEA ba su samu komai ba a wajenka game da zargi da ake yi maka na mallakan wannan wiwi da abin nan. Yace to bayan kai kana da wani wanda zai ba da shaida ne saboda ya karfafa maganan da ka faɗa nan? Bayan kai da kake ba da shaida yanzu, akwai wani shaida da za ku ƙara kira ya karfafa abin da ka faɗa?
Shaidan na wanda da kenta zai karfafa ya faɗa din babu, Allah ya yi marshika kanena ne. Shi muna tare aka yi. Amma ya yi rishi.
Kotu ya ji.
The first question that was asked or that was put to you by your counsel, that whether you know why you are before this honorable court today, you said you don't know. Am I right?
Tambaya na farko wanda lauya mai kare ka yayi maka a lokacin da ka ba da shaida da farko, tambayan da ya maka ya tambaye ka cewa ka san dalilin da yasa kake gaban wannan kotu, sai ka ce masa a'a baka sani ba, haka ne?
Haka ne.
Good. And he further asks you that it is not true, where you said that it is not true that you are not, because he asked you that whether you are facing charges in relation to having possession of 33.1 grams of psychotropic substance and 900 grams of cannabis sativa, in which you said no, you are not facing that allegation.
Kuma shi lauya mai kare ka ya sake maka tambaya cewa kana fuskantar tuhuma ne a nan kotu dangane da shari'a na zargi wanda ake zargin ka mallaki gram 33.1 da kuma grams 900 na tabar wiwi, wanda ka ce a'a baka fuskantar wannan tuhuma. Ka faɗi haka?
My lord, my question at that time.
Haka ne, ni ban san komai ba fa shi.
My lord, I think that at that time, the witness, he might have lost my questions. That means he didn't understand my question. That's why I put it to him that the witnesses come and testify in respect of the allegations against him. And at that time, he make his steps. He didn't understand my question at that time, my lord.
Mustafa, court registry. What was his answer to the question?
The question
asked by the last question asked by the prosecuting counsel.
Yes, he said he don't know anything in respect of this, my lord.
Okay. Yes.
And funny enough, you are now giving a testimony before this honorable court that you are brought before this honorable court to face an allegation which you don't know.
Ce kuma abin dariya, kai yanzu kana ba da shaida akan tuhuma da ake yi maka akan zargin mallakan kayan maye da ake zargi. Akan kuma kai ka ce baka san da wannan maganan ba ma gaba ɗaya. Me za ka ce?
Na san da maganan mana tun da ina kotu, amma ban san akan mene sharri dai suka yi mini ne. Duk abun da ya kawo ni nan ba da sani na ba.
Kotu ta ji.
Baba, if assuming now, if you are giving the Holy Quran to sway that exhibits were not found in your possession, will you? Will you check out with that?
Ya ce, Baba, yanzu misali idan aka baka Ƙur'ani, ka rantse cewa NDLEA ba sa samu komai a wajenka ba tattare da kai abin da suke zargi. Za ka rantse?
Zan rantse.
Za ka rantse?
Zan rantse.
Okay, now Baba will ask you to go and perform ablution.
Ya ce yanzu za a buƙace ka je ka yi alwala.
For you to swear that you did not deal in narcotic drugs. We will have the water for you now. Tell him to perform ablution. Tell him.
Sorry, Council, we are off for some seconds, please. Can you repeat what you said?
Never.
Tell him that we will now give him water.
You are not the judge now. You are not the judge. It is only discretion of the judge that will do that, not the prosecution.
Counsel, are you objecting or what? You
I'm
keep
objecting,
interrupting. So you open your mouth and tell the court they're objecting. But stop interjecting without, yes.
Stop, please, my lord.
I don't know.
My lord, I'm objecting.
Objecting to what?
My lord, the prosecution says that the witness he should take ablution to swear, while he is not a judge.
My lord, I wish to proceed. My learned friend is not.
There's a problem. Maybe there's a problem, a challenge with the network.
My lord, I wish to proceed.
Let me ask it for. Just give me 1 minute. I'm trying to, because can you repeat your question?
Okay, my lord, I put into the witness, my lord. I'm trying to test some of yes.
Just the question. That's all I need.
Yes, my lord. I said he will. We will give him water to perform ablution so that he can pray to the Holy Spirit. That was the question I put to him, my lord.
Counsel, I'm sorry, you are offline for some time. I didn't hear the question.
Sorry, my lord. I said to the witness that we will give him water to perform ablution so that he can swear to the Holy Quran that exhibit that he was not found dealing in narcotic drugs.
Is the defense counsel still with us?
My lord.
Are you there?
Yes, my lord.
Okay.
Abana, interpret, please.
Yawwa, ya ce yanzu za ka yi alwala, za a baka ruwa ka yi alwala, ka rantse akan cewa NDLEA ba su kama ka da komai ba, abinda lawyer mai gabatar da kara yake faɗa kenan.
To mu je a bani ruwa ni
Ka daga murya a jika.
Zan rantse mu je a bani in yi alwala.
Thank you very much, my lord. That's all for the cross-examination.
Defense counsel, is he still there?
My lord. My lord,
Is the
sorry.
defense counsel still online?
Yes, my lord. I can hear you, my lord. My lord, that is the end of the defense, my lord.
Yes.
And we are seeking a date, my lord, to address the court for our final address.
Can you
my
speak
lord.
up?
My lord, we need a date to address the court.
We shall be guided by the court, dear madam.
Yes, my lord. 10th October.
When? The date again?
10 October, my lord.
Okay. Ruling. This honorable court, having listened to the application for adjournment by defense counsel to address the court, this matter is hereby adjourned to the 10th day of October 2023. Meanwhile, the defendant is to continue to enjoy the bail, the bail granted him to the next adjourned date. Can you hear me?
Yes, my lord.
Okay. Let me change my source of, I can't hear you. Let me try. Can you hear me?
Yes, my lord. Yes, my lord. We can hear you, my lord.
Yes, my lord.
Okay, but okay. Matter adjourned to the 10th day of October. The defendant is to continue to enjoy the bail granted him to the next adjourned date.
As the court pleases.
Thank you, my lord.
Registry of court.
As the court pleases.
Okay. Matter adjourned to the 10th day of October.
Yes, we had it, my lord.
Okay, thank you. Please, can you call the next case?
Thank you.
As the court pleases. FSC/GM/CR/9/2022 between the Federal Republic of Nigeria versus Ya'u Musa. Yes, my lord, the defendant is present in court together with his counsel, my lord.
The defendant is present in court?
Yes, my lord, with his counsel.
Okay.
With the greatest respect and much honor, my lord Usman Bamala, my humble appearance is for the complainant.
Yes. Yes.
Defense counsel, you are on mute. Please unmute yourself.
Where's the defense counsel? Defense counsel.
Yes, my lord. I'm with you, my lord. The matter is slated today, my lord.
What is your name?
Yes, my lord. Respectfully and humility, A. Suleiman is my name, my lord. A. Suleiman is my name, my lord.
Yes.
My respective
Where's the
affairs-
defendant?
The defendant is in court. Our lawyer is the defendant, my lord.
Okay. Yes.
Yes. My lord, the matter is slated today for defense.
Yes.
And subject to the court convening, I'm ready with one witness, which is the defendant himself, my lord.
Counsel, please let the defendant come to the open court so that we can affirm him.
Okay.
Let him come to the open court quickly, please. Yes, my lord. Here is the defendant. Let me affirm the defendant first, please.
Mr. Abana, before you proceed and put him on oath for his testimony, my lord. My lord, this honorable court in the last adjourned date, which was the 13th day of June 2023, my lord. This court have, based on the prayers made by me, the complainant counsel, bench warrant has been issued by this honorable court. Summons to the sureties, as well as the defendant is foreclosed to enter defense, my lord. Therefore, my lord, for the counsel to the defendant to announce appearance and say that their intention is to enter defense, my lord, they have, it has been overtaken by event, my lord, as a result of lack of diligent prosecution of their defense, my lord. They may wish to take date to address this honorable court. Impliedly, my lord, they are resting on the prosecution case, my lord. This is the position. Thank you.
Councils, please be patient. My lord is getting network problem. Give us 1 minute.
Welcome.
Good afternoon. Good afternoon, Registry of Court. Can you hear me?
Yes, we can hear you, my lord.
Please call the next case.
As the court pleases. Charge number.
Let's go, please.
Charge number FSC/DM/CR/9/2022 between Federal Republic of Nigeria versus Ya'u Musa. Yes, my lord, the defendant is here present in court.
Okay. Yes. Representation, please. Okay.
Respectfully, my lord, my name is Usman Bamala. My humble appearance is for the complainant.
Okay, I'm sorry, the network is quite unstable.
Yes, my lord.
Mm.
Network in about it is a network that is bad.
Defense counsel?
Yes, my lord.
Okay, please, go ahead.
Okay, yes, my lord. My witness, my lord, is the defendant himself, my lord.
Yes.
Subject to court convener, my lord, I'm ready to proceed, my lord.
Registry of court, we're waiting for you.
As the court pleases.
My lord, my lord, up to now, counsel did not reply to the order of this honorable court in the last adjourned date, my lord.
Counsel, are you making a submission?
Yes, my lord, I did. I think maybe it was the network that deterred the court from perceiving it, my lord. My lord, I said in the last adjourned date, my lord, on the 12th day of June 20, on the 13th day of June 2023, this court granted a tripartite prayer raised by the counsel to the prosecution that the sureties are to be summoned, sureties to the defendant are to be summoned, bench warrant has been issued, as well as the defendant case has been foreclosed, my lord. So, my lord, if these prayers are still subsisting, my lord, counsel to the defendant cannot enter defense, my lord. He can, by implication, they have raised their case on that of the prosecution for lack of diligent prosecution of their defense, my lord. So, my lord, they can only take a date to address the court if they so wish. That's address in reply to the prosecution case, my lord.
Yes. Any response to that?
Yes, my lord. Yes, my lord. I have response, my lord. Yes, my lord. I sincerely and tender my apology to this honorable court of justice, my lord.
Yes.
Yes, my lord. I could remember on May.
Yes.
Yes, my lord. On May, we agree with the prosecution to take a date to 13 June 2023 for defense, my lord, and the defendant is in court In May 20.
You mean in the month of May?
Yes, my lord. That was when we took the matter for defense to June because I have wedding on 13 May. And the defendant is in court on that day, my lord.
That the matter should be adjourned?
Yes, my lord, to 13 June. Yes, my lord, to 13 June.
Yes. Counsel, are you still there? Counsel, are you still there?
My lord, we are there. That of the defense.
Because I was seriously sick, in which I could not even send in an adjournment letter, my lord, on the 13th June, my lord.
No, that's not an excuse. Counsel, you are before the court, you better give me good reasons. So such it's not acceptable. Yes, finish your submission quickly. Yes.
Yes, my lord. Yes, my lord. In the interest of justice, my lord, since the last adjournment is the first time the accused person is not in court, my lord.
The defendant.
Yes, my lord.
Yes.
And it's due to inadvertence of counsel because I normally used to call him to come from Damaturu to attend this trial, my lord. And
yes.
Equally, my lord, and equally, my lord, in the interest of justice, my lord.
Yes.
We are urging the court, my lord, to set aside the order earlier granted for closing the defense, my lord. And the bench warrant earlier issued, my lord. And if application is granted, my lord, we are ready to proceed, my lord. May it please, my lord. Thank you for the right of audience.
My lord.
Yes, I can hear you.
This is not the first time the defendant has been in absentia before this honorable court. My lord, I refer to the record of this honorable court on the 23rd day of June 2022, exactly last year, my lord. The defendant, as well as his counsel, both of them, my lord, they are not in court, my lord. My lord, on the 8th day of November 2022, my lord, the same thing, my lord, the counsel is not available and the defendant too is not available, my lord. This necessitates the prosecution to apply, my lord, for a summon and bench warrant against the defendant, my lord. In the interest of justice, my lord, this position was set aside on the first day of February 2023, my lord. And that was where we opted to close our case. The court adjourned the matter to the 9th day of March 2023, my lord, for the defense.
Matter adjourned to?
9th day of March 2023 for defense.
Yes.
My lord, the court did on 29th day of March 2023, my lord, the defendant apologize. The counsel to the defendant apologized to the court for the inavailability of his client on 29th day of March 2023, my lord. Where we reluctantly concede to the application and we ask for a last and a definite hearing date, my lord, which is 3rd May 2023 for the defense. And on the 13th June, my lord, on 13th June 2023, my lord, the defendant was not available as well as his counsel, my lord, where we make a tripartite application, my lord, and this court ordered same, my lord. So, my lord, as far as we are concerned, my lord, counsel has slept upon his right, my lord, in this matter, unless he has a better argument, my lord, that will make us to believe. But as far as we are concerned, my lord, this matter has been tactically delayed by the defense, my lord, for more than a year. We urge this honorable court to discontinent with the prayers of my learned friend, unless, my lord, he has a better argument and reasons. Thank you, my lord.
Prosecuting counsel, can you mute your microphone? Defense counsel, can you mute your gadget? Registry of court. Registry of court.
Yes, my lord, we can hear you, my lord.
Yes, give me a date.
As the court pleases. My lord, 11 October.
Thank you. Call them back, Madam Mustafa. Call the defendant back.
Court pleases, Your Honor.
Ruling.
As court pleases.
Counsel in court. Prosecution and defense
Yes, my
counsel.
lord, I'm in court, my lord. Yes, my lord, I'm in court, my lord.
This instant matter, which was slated for defense, was called. The prosecuting counsel, having closed their case, this matter was called. The defendant is before the court. Both the prosecuting and defense counsel are before the court. The defense counsel applied to open his defense, to which, by calling on the defendant as a defense witness, while the prosecuting counsel objected based on the application he made at the last adjourned date, which was granted by the court. This court will refer to the orders made at the last adjourned date in respect of this matter, portion to Section 122 Evidence Act 2011. I quote, "This instant matter, which was slated for defense, was called. The prosecuting counsel having closed the case since the first day of February 2023, and since then the defendant never showed up in court while the matter was adjourned countless times, only for the defense counsel to show up once, and that was on the 29th March 2023. This honorable court, having listened to the application of the learned prosecuting counsel and having confirmed same from the court file, all the prayers of the prosecuting counsel are hereby granted. The bail of the defendant is hereby revoked and a bench warrant to be issued. The sureties to the defendant are to be summoned at the next adjourned date to show cause, and the defense is hereby foreclosed for want of diligent prosecution. This matter is hereby adjourned to the 12th day of July 2023, end of quote." Now, this honorable court, having read out the ruling delivered at the last adjourned date, being the 13th June 2023, and having listened to the arguments of both learned counsel, will vary the order to an extent in the interest of justice. The order for the revocation of the bail of the defendant is hereby set aside, as the court cannot visit the scenes of counsel on the litigant. The order for closing the defense is sustained for want of diligent prosecution. Both counsel are to file in their final written address before the next adjourned date, much adjourned to the 11th day of October 2023. The defendant is to continue to enjoy the bail granted him to the next adjourned date.
As the court pleases.
Mustafa.
My lord.
Caution the defendant he should be mindful of because you always give him, I do see you writing the dates of adjournments and giving it to the defendant.
Yes, my lord.
So him that he should be attending courts. If not, his bail will be revoked.
As the court pleases. Kotu ta ce, Nutsu, kaga kullum duk ran da aka daga shari'anka muna rubutawa mu baku a rubuce. Ka zo kotu daidai ran da aka rubuta aka baka. Idan har kana kin zuwa kotu, belinka da aka bayar kotu za ta janye belin. Ka fahimta? Bude baki kotu ta je. Kai wa kotu godiya kuma.
Thank you.
Yeah.
Just call the next case.
Ga ranar. Charge number FAC/DM/CR/8/2021 between the Federal Republic of Nigeria versus Roland Osamezu.
Is it 18 or 8, 2021?
20 CR. I'm sorry, my lord. I'm sorry, my lord. CR 18, my lord. I'm sorry.
Yes. Yes, Correctional Center.
Good morning, my lord. Yeah,
Good afternoon.
My lord, defendant here at the Correctional Center.
Okay.
He speaks English.
Okay, thank you.
Thank you, my lord.
Respectfully, my lord, my name is Usman Bamala. My humble appearance is for the complainant.
May it please, my lord. My name is U.L. Lukman, and my respective appearance is for the defendant, my lord. My lord, the matter was adjourned to today for adoption of a final address on the part of the defendant. And subject to my lord's convenience, we are ready to proceed with same.
Yes.
I call you ready, my lord.
We are much grateful, my lord. Before my lord is the dependent final address, which was dated 24th day of March, 2023, my lord.
Yes.
My lord, we humbly apply to adopt same as the defendant final address.
Yes.
And urge my lord to so hold that the prosecution has woefully failed in establishing the case against the defendant. We thereby urge my lord to discharge and acquit the defendant, my lord. My lord, we do not file any further reply because the prosecution has waived their right of filing their final address. So we rely on our submission by urging my lord to so hold by discharging and acquitting the defendant. We are much grateful, my lord.
Thank you.
My lord.
Yes.
The complainant has not filed any written address as we have waived our own right of address, my lord. My lord, this is because no matter how an address is well argued, it will never take the place of evidence.
My lord, I am objecting to that. If he's so serious on that, you could have filed his final address, my lord. I waive my right, so you don't have right to speak again, my lord.
Thank you, counsel.
So, my lord, it will never take the place of evidence, my lord. We urge this honorable court, my lord, to take all the evidence let into cognizance, my lord, and also, my lord, the defense of the defendant, my lord. It is our humble submission that the defendant's defense is not a defense, my lord, rather an allegation.
You have, just like counsel said, you have waived your
address, of course, my lord. We did, my lord.
Yes. Okay. Thank you.
Thank you very much, my lord.
Ruling. This instant matter slated for adoption of written addresses by council was called. This honorable court hereby adjourns this matter to a date that will be communicated to council by the registry of court for judgment.
We're much grateful, man.
You're welcome. Let's call the next case.
Yes, my lord. That is all for today, my lord.
Okay, I thank registry of court. I thank council. They do have a restful day. Bye-bye.
Thank you, my lord. Thank you.
Thank you, my lord.
Thank you.